Hello, everyone, and welcome to One Civil Law. And for today's story, we are going to be discussing the U.S. Supreme Court just decided to hear a case relating to the Second Amendment coming out of Hawaii, which is nice because the Supreme Court doesn't really do Second Amendment cases for reasons that continue to pass my understanding. As I've pointed out before, since the Supreme Court decided the First Amendment existed sometime around 1940, they've been taking something like 3 to 6 First Amendment cases basically every year for the last 80 years. And not so much with the Second Amendment, right? They haven't really been doing that. They had Heller, obviously, and then they had McDonald much later, or later, and then they had Bruin. And they don't really like to do 2A cases for some reason. They don't like to do them. But they took one. They took one out of Hawaii. So we're going to read the petition for the writ of certiorari, and we might read the reply and talk about some of the oral arguments because that might be fun. Okay, so let's just start with the question presented in this case. The question the Supreme Court has been asked to hear, or agreed to hear, actually. We begin with New York Pistol versus Bruin, a case you know and love, holds the Second Amendment guarantees a general right to public carry of arms, meaning ordinary law-abiding citizens may bear arms in public for self-defense, with some caveats broadly correct. In this case, the Ninth Circuit sustained, not surprised, right? The Ninth Circuit would definitely be the one most likely to strike something down when it comes to guns, but yeah. The Ninth Circuit sustained a Hawaii law that makes it a crime for a concealed carry permit holder to carry a handgun on private property unless he's been given express authorization to carry the firearm on property by the owner, leaser, or manager. So this is basically a reverse of the normal rule. You know, pretty much every state is opt out, right? If you are a private business and you don't want people to carry a gun into your business, typically you have to post some kind of sign to that effect. Texas's law on this point is very specific, incidentally. You have to post a very specific sign. So that Texas is very anal about this. So, but that's the normal rule. Normal rule is opt out. But Hawaii is like, how about opt in? Unless you have permission, you can't carry into any private business. Okay, so that's the way Hawaii wants to roll, which makes things very challenging for a concealed carry holder, as you might expect. This holding is acknowledged in direct conflict with Second Circuit holding, a decision that struck down the identical state law in the same posture. So we have a circuit conflict. The Second Circuit, which, you know, wouldn't necessarily be your choice for the circuit most likely to strike down this law, nevertheless did. So that's nice. The Second Circuit said, okay, this law is unconstitutional. Ninth Circuit, unsurprisingly, said it's not. So you have a conflict between the Second and Ninth Circuits, which, of course, circuit conflicts are the most likely reason for the Supreme Court to say yes, so that's notable. Pressing on. The Ninth Circuit also sustained a multitude of other location bans on carry by permit holders, relying solely on post-Reconstruction era, after the Civil War, and later laws, which, of course, is important because when you're talking about what the Second Amendment means, what it means is what it meant when it was written. Right? Because the language was written at a particular place at a particular time, 1791, if you don't mind, or adopted in 1791. And so the question would be, what did it mean in 1791? Now, that question is going to be informed by all the precedent beforehand. But as the precedent is closer to the date, it will become more relevant, right? Because English common law has been going on for 800 years at this point, right? Or 600 years, I suppose, at the time of the founding. So English common law was 600 years old at the time of the founding. So there's 600 years of law that might inform what the Second Amendment meant. But, of course, what it is going to mean is that the cases that are closer in time to the Second Amendment will be more informative because, obviously, they were more likely, you know, referring to that. And also, you can look at cases that follow or writings that follow because you're looking for the contemporaneous nature to help understand what they were talking about when the Second Amendment. So the more contemporaneous to the Second Amendment, typically the better. So by the time you get to the Civil War, which is, you know, another, what would that be, 90 years into the future, or I suppose 70 years in the future, And the laws after that, they'll be a little bit less relevant to understanding what the Second Amendment meant. So the date of that is important. Okay, great. Let's see where we were. That doctrinal approach is in conflict with the Third Circuit's decision, the Fifth Circuit's decision, Eighth Circuit decision, and most recently the 11th Circuit decision, all of which hold the primary focus must be on the founding generation, traditional and applying text, which is basically what the Supreme Court has said. You know, that's, yeah, I mean, that makes the most sense, right? When you're looking to what the language of the Constitution meant, the writings that are most contemporaneous to that time frame are going to be the most relevant in understanding what they had in mind. I mean, that's logical, right? Because it was written with that zeitgeist in mind. And so, you know, things that are older than that might be informative too, but not as informative. Things that happen later might be informative, but not as informative. So, you know, unsurprisingly, most circuits say, you know, the more contemporaneous to the time of the writing, the better. But the Ninth Circuit isn't all about that life. They're about like whatever works to make our argument work, which seems like in pretty strong conflict with what the Supreme Court's already said on this issue, but you know, whatever. Thus, the question the Supreme Court has decided to pick up, they only took up question number 1, incidentally. So the question the Supreme Court is going to decide is, the question the Supreme Court's going to decide is whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. So that is the issue that's going to be held. I have to say that, you know, of all the Second Amendment cases to take, I'm slightly surprised the Supreme Court took this one. You know, I would think that they pick something that would be a little bit more easy to decide in favor of the Second Amendment to build up some more foundation. You know, this obviously not only is a Second Amendment issue, but I guess in the private property issues, which is concerning. So a little bit surprising they took up this issue, but they did. And so that's all there is. And question number 2 was not adopted, so we don't have to read it because they didn't accept that one. They only accepted question number 1. All right, so let's read a little bit through this and see what it has to say in terms of the argument. So there's statements of related proceedings. That's nice. Question presented. Blah, 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 blah. You know, all the appendices, tables of authorities. Looks pretty, as it should. Pages of authorities goes on for a while. Okay. The petition. Ninth Circuit sustained Hawaii's nearly universal restriction on handgun carry by licensed concealed carry permit holders, which, by the way, getting a concealed carry permit in Hawaii isn't exactly easy in the first place. But I digress. On property open to public, carry is permitted only if the permit holder has been given express authorization to carry a firearm on the property by the owner, lessee, operator, or manager of the property. That holding creates a direct circuit split with the Second Circuit, which struck down the identical New York law, which, you know, again, like the Ninth Circuit would probably be the most likely to uphold this, but, you know, the Second Circuit coming out of New York, you know, you think would not necessarily bend over backwards, but they went the other way on that issue, which something to be said for the Second Circuit, I guess. Ninth Circuit also erred by giving decisive weight to local and state laws enacted well outside the founding era to sustain total bans in all parks and beaches, playgrounds and youth centers, bars and restaurants that serve liquor, and places of amusement and libraries. Such reliance is incompatible with Bruin. Yeah, pretty much. The Supreme Court said basically that. And Ramini, where this court admonished that the court must ascertain whether a new law is relevantly similar to laws that our traditions understood to permit applying faithfully the bounds struck by the founding generation. Right, because the language was written when it was written, and so the people that wrote it obviously had certain things in mind when they were writing it, and how do we know what those things in mind were? Well, other writings, the more contemporaneous, the better, would give us some pretty strong clues about what they were talking about. So, in other cases, another precedent, another common law that is at the same time period, that's obviously going to be the most relevant. So, when you're trying to figure out what they thought, trying to figure out what they were writing against, seems like a pretty good strategy to me. Yeah, that makes sense. The Ninth Circuit reliance on such analogs, also conflicts with decision 3rd, 5th, 8th, and 11th, all which say, founding error is best error and other stuff less so. Yeah. In holding the Second Amendment does not apply to property open to the public. Well, I suppose it doesn't indirectly because a private actor is not the government. But when the government passes a law concerning private property, then it's the government acting. So the Second Amendment doesn't apply to the private property owner, I suppose, but when the government is passing a law, that obviously could have Second Amendment implications, as well as other implications. Yeah. The Ninth Circuit's reliance on non-founding era analogs allow states to enact law the founding generation would never have allowed. Fair. Ninth Circuit effectively allowed Hawaii to eviscerate the general right to publicly carry. Yeah, I mean, again, like, if it's banned all private property unless they give you permission, that does make concealed carry really challenging because you can't really go anywhere, right? If it's banned everywhere. So that's a problem. All right, pressing on. Jurisdiction statements. Okay. The scheme. In 2023, the legislature enacted a law specifically to negate Bruin. Of course they did. The legislation criminally prohibits a person with a concealed carry permit from bringing a handgun onto 15 types of property. The law also flips the default rule on all private property, whereas prior law allowed a person with a carry permit to bring a firearm onto private property open to the public unless prohibited, which is the much more typical rule. The new legislation prohibits it unless permitted, which you can do by unambiguous written or verbal authorization or the posting of signage. Petitioner challenged the default rule position. Petitioner also challenged several other positions enacted. Those provisions prohibit them from carrying a firearm in any building or office loaned, leased, or used by the state or county and adjacent grounds or parking areas, which, again, raises serious problems because any building owned by the government is necessarily a sensitive place. I don't think so. Any beach, playground, park, or adjacent parking area, that covers a lot of ground. Any bar or restaurant serving alcohol or intoxicating liquor. I wonder slightly what the difference between alcohol and intoxicating liquor is. Not 100% sure on that one, but okay. And the premises of any bank or financial institution. The Ninth Circuit ruled in petitioner's favor as to the banks, and partially in their favor to the extent the challenge deals with parking lots shared with prohibited location and non-prohibited location. The court, however, sustained the default rule, presumptively banning carry on private property. It also sustained the bans on beach, playground, park, or adjacent parking area and bar or restaurant, which would cover a lot of territory, I would imagine. Plaintiffs are residents of Maui, Hala, who wish to, do the things that they're not being allowed to do. Okay, and then we filed a suit, and there were some decisions, blah, 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 blah. Okay, the petition presents two separate sets of circuit splits, one for each question presented. Again, they only adopted question number 1, so we can ignore exciting question number 2. First, there's a direct conflict on the constitutionality of the default rule. So, yeah, basically the circuit split is going to be the thing. So we got a circuit split between the Second and Ninth Circuit, and that's the most common basis for the Supreme Court to grant review. Normally, although a single to single circuit split normally is not even enough to get the Supreme Court's attention, because there's a lot of single to single circuit splits. Normally, to get the Supreme Court's attention, you need it would be helpful if you had 4 or 5, circuits that have expressed an opinion. And preferably, it would also be nice if there's 2, 3, maybe 4 different opinions, right? So the more circuits involved and the more fractured it is, the more likely. So this is simply a 1-to-1, which is not your most likely category, but nevertheless, Supreme Court said yes. Again, I wouldn't think that if they were looking for something to do on the Second Amendment, which there's lots to do, I'm not sure why necessarily this particular case, it's because I'm just thinking about this logically. Like, what is the next logical step, right, in the Second Amendment case law? You had Heller, which is maybe you can have a handgun in your house sometimes if you're in D.C. Then you had McDonald, which is maybe you can have a handgun in your house sometimes if you live other places in the country. And then you had Bruin, which said maybe you can carry a handgun outside of your house sometimes, maybe. Right? So, like, is it the next logical step to deal with private property issues? I don't know if that's necessarily the next logical step in the analysis or the next place to logically go, but that's what we're doing for some reason. So, okay. The Supreme Court has a plan, one hopes, and this is what they're going with. Okay. Or they just think it's like so outrageous that it's an easy win, but I don't know. Okay. Anyways, pressing on. The Second Circuit held the analogies fail, yet the Ninth Circuit said the same analogies were fine, or analogs were fine. Yep. And then we can ignore the second split because the Supreme Court didn't take that issue. Okay. The Ninth Circuit decision in this case creates a circuit split on whether governments may presumptively prohibit the carrying of handguns by licensed permit holders on private property open to public without affirmative permission. The Ninth Circuit and Second Circuit acknowledge the split, as they do. On this point, the Second Circuit got it right. I mean, obviously, to be sure, private property owners may decide to exclude people from their property, of course, but that power resides with the property owner, not the government. There's no comparable history, not even modern day, tradition of allowing government to create a no-carry default rule for private property. And again, this is all about the governmental action, right? It's like, what is the governmental property right, or the governmental rule when it comes to the Second Amendment, right? Because the property owner doing this themselves raises less constitutional concerns. But the government saying this is a default rule, creates concerns because it's government forbidding something, right? If the government said it's typically allowed unless the private owner says no, then the only person saying no is the private owner, right? Because that's the rule in most states. It's allowed typically unless the owner says no. And in Texas, to say no, you have to say no in a very specific way. But that makes sense because then the only person saying no is the private party. If the default rule is the other way around, it's the government that's saying no. And therefore you have a problem because you have state action. Yeah, so that makes sense. The Ninth Circuit ruling stands alone. Well, there doesn't seem like there's a lot of decisions because apparently it's only the Second and Ninth Circuit, so saying it stands alone is a little misleading, but okay. The Ninth Circuit first correctly found that carrying on private property open to public falls within the Second Amendment right. Fair enough. So the Ninth Circuit believes that carrying on private property that is open to the public is within the Second Amendment in the first instance. So that's something you could disagree with, at least theoretically, but even the Ninth Circuit's not willing to do that. So they're like, yes, carrying a handgun onto private property is generally speaking within the Second Amendment right. So you know right away that they're going to be in trouble, right? The panel then cited to a series of laws that prohibit carry firearms onto subsets of prior land, such as plantations or enclosed lands, holding that those laws likely did not apply to property that was generally open to the public, and the primary aim of those laws was to prevent poaching. Okay? However, the panel then went astray when it relied on two other laws, a New Jersey law enacted in 1771 and a Louisiana statute enacted in 1865 to sustain Hawaii's no default carry rule. Well, I notice a problem right away with relying on a Louisiana law from 1771. You want to know what that problem would be? Well, here's some problems related to this. Okay. In 1771, there was no United States. In 1771, Louisiana wasn't a state. In 1771, Louisiana was France. Do you remember your history about the whole like Louisiana Purchase thing? That was Jefferson when he was president, third president of the United States. Anyone remember this? When Jefferson bought Louisiana from the French. So there are a couple problems with this. It wasn't a state. It wasn't a territory. And it wasn't even English. So in trying to understand what the Second Amendment meant, which is from the English common law tradition, it doesn't make sense to cite French common law, also for the reason that there's no such thing as French common law because they're a civil law system, not common law. So there's just a multitude of problems with citing Louisiana from 1771. Not a state, not a territory, it's not even British, and there is no common law because the French don't believe in it. So there's all those things. Just some minor issues. Shit. Yeah. That's a problem on that one. So we'd like to cite. Oh, the Louisiana statute was from 1865. I read the wrong way around. Okay, sorry, my bad. Okay, I'll stop mocking them now. Sorry, I read the wrong way around. Louisiana was 1865. My bad. Okay, Louisiana was a state. Never mind. Although there's still a civil law system, so there's still that, but I'll mock them less now. Sorry, my bad. Although New Jersey wasn't a state in 1771 because there were no states in 1771, but that's okay. Anyways, pressing on. There was no United States in 1771, so yeah. Anyways, pressing on. Ninth Circuit decision was based solely on the two laws, even though the Second Circuit expressly reject both as significant. Yeah. Citing law from Louisiana is always a little tricky because Louisiana is still to this day a civil law system. So, of all the states to cite, Louisiana, any of the other 49 states would be a better choice. Because Louisiana is often its own little legal world for some reason. I don't really understand it. I'm not even sure the Louisianans understand it. But, that Louisiana bar exam's got to be a bitch. How do you even do with the Louisiana bar exam? I don't even know how you're supposed to do this, even in principle. First, the Louisiana law in 1865 was part of the Louisiana Black Codes. It was enacted right after the Civil War before Louisiana was readmitted to the Union. So at the time, that's great. So in 1865, Louisiana wasn't part of the United States. Oh yeah, okay. Yeah, so in 1865, we're part of the United States. Okay, so that makes it even trickier. All right. The enterprise of Black Codes was their attempt to stabilize Black workforce and limit economic options apart from plantation labor. Okay, nice. The Black Codes were also designed to deprive newly freed slaves of civil rights, including the right to keep and bear arms, as otherwise protected by state law. Yeah, there was a lot of that at the time period. You walk in looking and talking like Colonel Sanders? Well, that's Kentucky, not Louisiana. Because Kentucky has that whole colonel thing, which is weird as shit, but whatever. Courts should not infer historical tradition or regulation consistent with a private building consistent rule from such a statute. Until this case, to our knowledge, no courts relied on a Black Code statute suitable analog. Yeah, looking at these laws that were trying to strip Black people of their rights to keep and bear arms, not really the best. Yeah, that's rough. You gotta love that by Hawaii, right? Hawaii, you normally think of as a pretty progressive left-leaning state, right? Pretty reliably blue, right? Hawaii, it's been a hot minute since the Republicans won Hawaii. Nixon, I guess, probably is the last time they won Hawaii. But, I'm not sure citing to the laws that were meant to deprive, former slaves of their gun rights is necessarily the play, especially in Louisiana with their plantation systems. Seems like a bad law to cite, but apparently Hawaii is cool with it. $5 from Sugo. How does Louisiana work for precedent? Whereas the civil law constitution said common law one. Yeah, they don't do precedent under state law. That's not really a thing under state law. It's yeah. Yeah. Do they just kind of do their own thing? Yeah, they kind of do. It's a very strange system from my perspective. But yeah. The panel's decision is the first. Well, I don't know about that, but it's just bad pool in any event. An outlier law designed to disarm former slaves enacted by the former Confederate before being readmitted to the Union. That's a good question. Are they still a Confederate state before they're readmitted to the Union? Even though the Confederacy has given up? What are they at that point? That's a good question. Yeah, I never really thought about it. So after the surrender, were the Confederate states still Confederate until they rejoined the Union, or what were they? I never really thought about it. Okay, pressing on. The panel's decision is the first. An outlier law designed to disarm former slaves enacted by former Confederate states before readmission cannot be proper part of our nation's history. Yeah, I mean, again, citing these laws seems like a bad play. Ninth Circuit erred in giving it meaning. Yeah, that seems like it. Yeah. This only leaves New Jersey's 1771 law, which generally banned the carrying of firearms on any lawns. They were always U.S. states just in rebellion. That leaves only New Jersey's 1771 law, which generally banned the carrying of firearms on any lands owned by another. That law is both an outlier and not comparable to Hawaii law. And they don't, yeah. That law is both an outlier and not comparable. An analog not need be historical twin, but must be well established and representative, and can serve as an analog only if it's distinctly similar and comparable how and why. Bruin expressly suggests placing meaningful weight on that solitary statute. Oh, so Bruin has already rejected using this statute? That's nice. Yeah, so that's pretty good play by them. Yeah, you cited a law that the Supreme Court has already kind of ignored in prior decisions, and you want to use it again. Yeah, this is not the first time I've seen this done, and it doesn't end well. I've seen it done before. It's like, let me use something the Supreme Court's already struck down, try to use it again. It doesn't tend to end well. So that's a bad play. That's not a great play, but I guess it's all you have to work with. So one law is horribly, horribly racist as the last throes of the Confederacy. And one law has already been told, and one law the Supreme Court's already told to go away. All right, let's see if that helps. In Ramini, the surety and affray laws on which the court relied were rooted in common law at the founding and were codified in founding era statutes in at least 4 states: Massachusetts, New Hampshire, North Carolina, and Virginia. I apologize that I'm still hacking up a lung. I know that does not necessarily make for the best streaming content. I apologize. Moreover, New Jersey's 1771 law is not a proper analog for other reasons. To be relevant analog, A law must impose a comparable burden on the right of armed self-defense, and the burden must be comparably justified. And it means how and why the regulations burdening a law-abiding citizen's right to armed self-defense must be comparable. Let me get some cough medicine real fast. See if that helps. I still have some prescription cough medicine for all the good it's helped doing. Let's try that. I'll be right back. Okay. Let's see. The New Jersey Y for its 1771 ban was to prevent trespass on enclosed lands by poachers hunting with guns. Its preamble demonstrates its anti-poaching purpose. Nearly every other provincial law expressly regulated hunting or trapping. Even New Jersey's Supreme Court has characterized it as punishing violations of fish and gaming. The Ninth Circuit thought the 1771 New Jersey law was a dead ringer for Hawaii private property law default because it applied to all private property. In contrast, the Second Circuit held the same law was not a proper analog because it applied only private property that was not open to the public. As the Second Circuit stated, no matter how expansive we analogize, we don't see how a tradition of prohibiting illegal hunting on private lands supports prohibiting the lawful carriage of firearms for self-defense. On this issue, the Second Circuit is right and the Ninth Circuit is wrong. The law in question made it unlawful to carry any gun on lands not possessed and from which the owner pays taxes or lawful possession unless he hath a license. Similarly, Section 6 of the New Jersey statute set property qualifications for hunting on waste and unimproved lands, suggesting an earlier provision not prohibit hunting on unimproved private land. Other provisions of the 1771 enactment were likewise focused on regulating time and manner of hunting. Thus, the law provided for repeal of all former laws made in the colony for the preservation of deer and other game and prevent trespassing. Finally, the New Jersey law applied to carrying any gun, not firearm. At the founding, guns were long guns or cannons, not pistols. Ah, that's interesting. That's interesting. So trying to say that when they said gun, they meant only long guns. That's cool. Pistols at the founding were short-range weapons capable of self-defense, not hunting, or not regulated by trespass laws aimed at prohibiting trespassers from using guns to poach game. Interesting. The Y of 1771 is not remotely comparable to the Y of Hawaii's law. A person on private pistol property, they had property. No one's saying they didn't have pistols. They're saying that's not what the word gun meant. They're saying the word gun did not mean pistol. That's what they're saying. Otherwise, open to the public is not simply trespassing, much less posting or hunting. And there's no evidence that the New Jersey law was ever enforced against anyone who is neither a poacher nor trespassers. How do we know what they meant if not written? The same way you understand anything else. They cited a dictionary provision. That's how. Well, that's their argument. Like, that's exactly what they did, right? Yeah. So they cited New Webster's American Dictionary of English Language from 1828. That's how they know, by using dictionaries. Vicks Tic Tac size cough drops. Ooh, interesting. The how is also different. Hawaii's presumptive ban applies to all private property held up in the public. The New Jersey law had a narrow scope because it affected only improved land. Certainly nothing in the history or tradition supports Ninth Circuit's frankly bizarre distinction between California's default rule, which the panel struck down because it allowed permission to be granted only through signage, and Hawaii's default rule, which allows permissions via signs or orally. The panel never explained why or how this distinction in the manner in which permits is given mattered under Bruin. The panel noted only there was no historical support for stringent limitation. The statement is unquestionably true, but the point's hardly controlling under Bruin. The pertinent history, tradition, concern stops people from trespassing on lands for the purpose of poaching with guns. The law of trespass does not turn the slightest whether permission is given orally or written by signage. Fair. As noted, the founding carry on private property open to the public was generally permitted. The Ninth Circuit panel did not dispute the point, but they just ignored it. Fair enough. The right to carry on property open to the public flows from the right of an implied license. Generally, the public has implied consent to enter property open to the public unless such consent is conditioned or subsequently revoked. And because the right of armed self-defense follows the individual everywhere he or she goes, in public carrying a property open to the public is permitted unless the property owner withdraws consent. There's no tradition, either in the founding or even in the modern era, of requiring prior permission from a property owner when entering land that's otherwise held open to the public. The relevant case also held the panel erred its unreasoned refusal to follow the holding. Very nice. Yeah, the Bruin held the Second Amendment guarantees a general right to carry, meaning ordinary law-abiding citizens may bear in order for self-defense. This is probably the best line of argument here, I think. This is the one that works for me. Property open to the public is part of the public space. As Bruin holds, there's no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it's crowded and protected generally by New York City Police Department. Thank you, Alan Parker, for the 20 gift memberships. Bruin found such a rule sweeps far too broadly because it would in effect exempt cities from Second Amendment and would eviscerate the general right the public to carry their self-defense. Excuse me. Okay, and we're back. Sorry for that interruption, but you know, work waits for no man. Where were we? All right, Bruin found that such a rule sweeps far too broadly because it would in effect exempt cities from Second Amendment and would eviscerate the general right to publicly carry arms for self-defense. Hawaii's law effectively does the same thing. As Judge Van Dyke wrote, Hawaii's law prohibits presumptively or outright the carrying of a handgun on 96.4% of the publicly available land. Yeah, pretty much. And has effectively nullified the Second Amendment rights. Yeah, pretty much. Too. Default rules are inherently sticky. The default rule was designed to make carrying firearms very inconvenient, so fewer people will carry them. Fair. As the Ninth Circuit noted, Hawaii adopts its default rule knowing it would be effective means of discouraging lawful carry. And then they cite something that says, though both of these rules give business owners the final say on whether to permit guns, the former regime will almost certainly result in less gun carrying overall due to the inevitable stickiness of default rules. The purpose, which is to discourage the exercise of constitutional rights, is illegitimate. I like that one too. Yeah, so it's not only the law itself, but the purpose behind the law. And because you're in a constitutional law analysis or a Second Amendment analysis, you're thinking you have to find a legitimate purpose, right? Because that's what happens when you get to higher tiers of scrutiny, right? No longer has to be a legitimate purpose, it has to be a important purpose or a compelling purpose, you know? So the purpose and motivation behind the law becomes very important. So very nice. I like that a lot. The record reveals this practical reality. The Ninth Circuit noted many property areas were not post signs of any sort or give specialized permission, regardless of the default rule. The reality was the impetus. That result is Hawaiians, including petitioners, no longer may carry firearms for lawful self-defense in tens of thousands of private property locations. That result is impossible to square with the general right to carry in public. The Ninth Circuit has thus permitted Hawaii to eviscerate the Second Amendment right Bruin gave. I like that argument very much. So I find that, I find that very good from a persuasive function, looking at how this has serious practical effect. So that section of the brief pleases me. And then there's also a section dealing with the analogs themselves, but the Supreme Court didn't take that question, so we can just kind of completely ignore the second half of this brief. Let's see. So where are we now? Okay. Relevant time period and functional importance. Yeah, okay, we can skip that. Barrett's petitioners. Arms are hunting, still skipping. And then we just get to the conclusion. Very good. So that's it, right? Because half this brief, the Supreme Court did take up the second issue. So half this brief disappears basically into meaninglessness. But I like what they have in the first half. I'm not sure I necessarily agree with the Supreme Court taking this particular issue. It seems, I really kind of want the Supreme Court to just kind of do some small fry cases. I just want them to do some Second Amendment small fry stuff. It's just really easy, picky and shit, right? It's really easy, really like picky and bullshit, just to build up some case law for a while, just to build a foundation so that you have some stuff to work from in future cases, right? So if the Supreme Court had spent like the last, say, decade and took 3 bullshit Second Amendment cases every year and decided 3 bullshit Second Amendment cases every year, well, you'd have 30 bullshit decisions. But those 30 bullshit decisions would have a lot of language in them that helps to contour some of the boundaries and can be used in more meaningful decisions because you've done some foundational work, right? So the sum is greater than the sum of the whole is greater than the parts. Even in that kind of thing. So, like, I really wish they had done that, but they have been doing that. And this does not feel like the next logical step. And it feels like a fairly aggressive step, to be honest. But maybe the Supreme Court's in a more aggressive mood today. I don't know, man. Should be fun. Well, for those of you who don't know, For those of you who don't know, the Supreme Court term starts the first Monday of October, which is this upcoming Monday, which I believe is the 5th. It's the 6th. I was close. So the Supreme Court term starts Monday the 6th, because it's the first Monday of October, and it ends the last day of June. Right? So the new Supreme Court term is going to start. Very exciting. And there are two interesting issues to be decided right at the start. So I find interesting issues. So we're going to be covering that. On Monday, the 6th, the Supreme Court will be hearing oral arguments in a case dealing with when a defense lawyer can speak to their own client while the client is on the stand giving testimony, okay? So the rule now is you can't, as an attorney, speak to your client or any other witness while they're on the stand, right? You, as a lawyer, have the ability to talk to witnesses before they get on the stand, right? You can depose the other side. You can obviously talk to witnesses on your own side, so there's opportunity to talk to witnesses beforehand. But what you can't do is once they're on the stand, talk to them, because that doesn't make any sense, right? They're on the stand doing their Q&A as they do, right? So if they're called at like 3 p.m. and now it's 4 p.m. and they're still on the stand testifying, right? Would it make any sense for to be like, let's have a discussion? That doesn't really a thing, right? Because it's like you don't really do that, right? And so that's true even after the trial's done for the day or the weekend, as the case may be. So the legal fiction is they are on the stand until they're not, right? So if you call me at 3 p.m., on a Thursday, and my testimony takes 10 days, then the fiction is that I was sitting on the stand the entire time, even when I was at home and stuff and taking showers, right? So for the same reason you can't talk to them, in the courtroom during the middle of testimony, you can't talk to them over the evenings or over the weekend during their testimony. Okay, that's the rule. Well, some lawyers are challenging that and saying that's unconstitutional. We should be allowed to talk to our client, overnight or over the weekend, even though they're on the stand. So in this scenario, the criminal defense lawyer has decided to call their witness to the stand to give exciting testimony in their own trial, right? So they have called their witness to the stand to give their own client to the stand, the defendant, to give exciting testimony. And during their own Q&A or during the prosecutor's Q&A, during cross, they would like the ability to talk to their client in a substantive way relating to their testimony. And now they can't do that, and they think that's unconstitutional. So that's Monday's oral argument. Is that constitutional or not? So that's kind of exciting. So we'll see how that goes. And then Tuesday is a controversial argument. Yeah, very exciting. It deals with conversion therapy out of Colorado. So this will get no one's, dander up, as they might say, right? So Colorado passed a law that allows licensed therapists, licensed psychologists, to encourage but not discourage LGBT status, including, incidentally, at the patient's own request. So you're a psychiatrist in Colorado, and a patient comes to you and says, I was born biological male, but I believe that I might actually be a woman. I believe I might be trans. And I like that about myself. But the world is cruel to me. My parents are mean to me. My spouse doesn't understand me, blah, 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 whatever, right? So you as a therapist in this scenario would be permitted to give them counseling that would promote them being LGBT, right? They feel like they are LGBT. They like to be LGBT, and you're allowed to give therapy to promote that status. So that would be encouraging them, right? You're allowed to give encouraging. Okay, but what about the opposite scenario? Which, incidentally, these doctors have these patients. So it's not purely hypothetical. they say we actually have these patients. Okay. So in this hypothetical, a person comes in and says, I was born biological male, but I'm feeling like a woman, but I don't want to feel that way. I don't like this feeling. My religion tells me it's wrong. I think there's something wrong with me. I think it's a mental disease. I don't know what's going on. I don't want to feel like a woman. I was born a male and I believe I should be a male. My religion teaches me to be male. My family teaches me to be male, and I agree with it. Right? That's what I want. I want to be more male. Okay. In this scenario, the therapist is not allowed to discourage them from being LGBT, even though that's what the patient themselves wants. So even though the patient says, I'm trans, but I don't want to be, help me, the therapist is not allowed to give therapy that would discourage them from being LGBT. They're not allowed to give that therapy, okay? Even if the patient's on request. So, viewpoint discrimination. Viewpoint discrimination, right? Because we have a government, right? Because the licensing of therapists is done by the government. It's done by a state entity. It's the government. The government's the ones that license the therapists, and says, you can talk about this issue, so it isn't subject matter. It's not like you can't talk about LGBT at all, which, is its own thing. It's actually worse than that. It's actually worse than saying you can't talk about it at all. It's saying you can only talk about it positively. And that's viewpoint discrimination. So the government has, by law, instituted viewpoint discrimination that prevents the therapist from giving certain speech. And there was a case many, many moons ago that said, there is no general professional speech exception to the First Amendment. Because that was a question for a while, right? Is professional speech in some sense more regulated or treated differently because it's professional? Because we license lawyers, because we license doctors, because we license therapists, is there some sort of special professional speech caveat to the First Amendment? And 20 years ago, the Supreme Court said no. So there's no professional speech exception. The fact that it's professional speech doesn't give you any additional ability to regulate it, as opposed to non-professional speech. That is not a thing. So there is no such thing as professional speech within the confines of the First Amendment, right? There's just speech. So so it seems like, therefore, this law should die a horrible, horrible death. Because discrimination on the basis of viewpoint is strict scrutiny, if not per se unconstitutional. Because Texas v. Johnson, which dealt with flag burning, implied that viewpoint discrimination is per se unconstitutional, which would mean it's always unconstitutional no matter what. No exceptions, no tests, right? It's just a black and white rule, right? And so that was implied by Texas v. Johnson. And so if it's a black and white rule, then, you don't really need an analysis at that point because you're just done. So, but that's going to be argued on Tuesday. So, when that decision is decided, as it will be, let's say around January, maybe February, when that decision, or maybe they'll wait till the end of the year just for that extra spice, but we'll see. When that decision is decided, and the Supreme Court strikes the law down, 6-3, which of course they will. The people are going to scream bigotry and, trans death and blah, 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 blah. So all that stuff, right? But yeah, that's going to be argued on Tuesday. So we will definitely tune into that oral argument, later next week. Well, KZ, no. I mean, if that analogy doesn't work, because a tankless water heater or a tank water heater has nothing to do with the First Amendment. There's no First Amendment interest in a tankless versus tanked water heater. So if you're just trying to do it by analogy, I guess. But if you meant it literally, then not so much. The government could ban tank or tankless water heaters, as the case may be, and it would not trigger a First Amendment analysis. So it doesn't quite work. It is professional speech, yes, but as I mentioned earlier, what is professional speech? The actual waters, the actual tank? No, the tank is a tank. It's a physical object. It's a device that does a thing. It's a machine. The tank is not a tank. The tank is not speech. The tank is just a physical object that heats water, or not, or tankless. It is not a speech thing. No. The plumber's opinion? Yeah, well, the plumber's opinion would be speech. Yeah, so if the law is you can't recommend it, then yes, that would be speech. If the law is you can't install it, no. That would not be speech. So if the government said, plumbers, you can't recommend the tankless water heater, that would be a problem. If the government said, plumbers, you can't install the tankless water heater, it's not a First Amendment problem. It's something else maybe, but not First Amendment. So that's exciting. And then in personal news, I'm going to have to wind up suing my landlord over $70. This is like the stupidest lawsuit ever because I'm totally right. So I had a problem where there was apparently not sufficient, that my landlord claims that there was not sufficient funds in my checking account. My check, electronic check, got bounced for non-sufficient funds. And they tried to charge me a $70 fee. No, they tried to charge me a $100 fee. I'm sorry. They tried to charge me a $100 fee for non-sufficient funds. And they said, well, we can do it because it's in the lease. The lease says you owe us $100. And I'm like, well, that's exciting and all, but a lease is fundamentally a contract. It's a contract. It's a contract for a specific thing. It's a contract for, being able to use being able to use a piece of property, but it's just a contract. And like any contract, it has to be legal, right? I mean, it's not that complicated. A contract cannot contain illegal provisions, right? When contracts contain illegal provisions, they are void. You can't contract to illegal things. Duh, right? That doesn't make, you can't contract to illegal things, duh. So, unsurprisingly, Texas's code says you can't charge a fee for a bad check of more than $30. It's in the law. It says the limit for a bad check is $30 in the law. And my landlord's over here like, but our lease says 100. And I'm like, yes, it does. Your lease is illegal. As to that, your lease is illegal because it charges more than you're allowed to charge. And I gave them notice of this like 20 days ago, and they still haven't refunded my money. So like on the 1st, and they got the letter today, I know because I sent it certified mail, because of course I did. I sent them certified mail to my landlord at both, their business address here where I live. And of course I sent it to their registered agent, because we're going to elevate this. It's like, okay, fine. We'll kick this up a notch. So, I sent it to their registered agent by certified mail, return receipt, blah, blah, blah. I'm like, I am going to sue you over $70. This is retarded. Give me my money back. So we'll see. Oh, Jeremy, no, this is great. No, it's even better than that, Jeremy. No, this is you see, this is the genius of this. Okay. It's like probably not to make matters worse when I need a reference. First of all, I don't need a reference from these people. I've never needed a reference from any landlord. No landlord has ever asked me for a reference from my previous landlord. That's not a thing. Second of all, they actually can't not rent to me now because I'm protected by another statute. because I am bitching, because I'm bitching, they're actually prohibited from retaliating against me. There's anti-retaliation provisions in the law, and it is considered retaliation if they refuse to renew my lease. Yeah. So they actually can't refuse to renew my lease because I bitched at them. And if they say that we're going to not renew your lease, I'm going to sue them and say you're doing it because I bitched at you. And like I said in certified mail, they're going to say what other reason they have, and they're not going to be able to come up with anything. They're not going to be able to come up with a reason, and it's all pretext anyway. So they actually can't now not rent to me. They're required to keep renting to me because they're not allowed to retaliate against me, including by canceling my lease or not renewing my lease. Because that's in the law too. Yeah, I looked into this. I got it prepared, baby. It's almost like I'm a lawyer. So it's like, I thought about this already. I got it under control. It's fine. There's lots of reasons they could make up. Good luck. Good luck. What are they going to say? I have a history of readily paying them on time. I'm not like beating down their door for like repairs all the time. No noise complaints have been ever directed my way. They've never contacted me like about a noise complaint or any other issue. There's no record. They can't just, what are they going to do? Oh, we decided not to rent to him because what? What reason are they going to come up with? And how are they going to document that reason? I look forward to them trying as I just go to court and tell them this is bullshit. It'll be fine. Yeah. And if it were just repairs, right? And exactly so. Like Miss Mandy, and if it were just repairs and things are actually broken, they're required to repair it. So if I came and see, hey, this is broken, and it is broken, they're required to repair it anyway. So I'm not. What basis do you have? So yeah. Is reason required not to renew a lease? Not typically. No. Not typically. You don't need a reason not to renew the lease, but they need one now for the reasons I just said, right? Because the law prohibits retaliation. The law prohibits retaliation because I raised these issues. And so normally they don't need a reason, but now if they don't renew the lease, I can say it's retaliation because the timing, right? And now they need a reason because the law protects me against retaliation. So they need a reason now. I'll have a case on record for failing to pay and suing the landlord. First of all, I did pay. I did pay them. They didn't send me an eviction notice. The moment the check bounced, I paid them immediately. They never sent me an eviction notice or notice to quit because I paid them immediately. Once I noticed the problem, I paid them right away, instantly. So there is no failure to pay. And I paid them the rent this month. So there's no record of failure to pay. And, the way I figured it, if I were 70, here's my view. If I were $70 short from them, for an absolute certainty, they would come after me for those $70. Right? You know that, right? They would come after me for the $70. So why shouldn't I, turnabout's fair play? And they are being a little bitches about it right now. They're being bitches. So they would come after me, so I'm going to go after them. Fuck them. Fuck them. Well, Jeremy, I appreciate your input, but you are more than free to handle a comparable situation the way you see fit. If I was your lawyer, I would give you the advice. I would tell you what your options are, and then you would make the decision as the client what you wanted to do about it. And if you wanted to pursue a different course of action, that's fine by me. You're the client. I don't care. I'm just here to help you make your dreams come true. So if you were in a comparable situation and you wanted to go about it a different way, more power to you, my friend. That's why we all have rights. You can choose to pursue it any way you see fit within the meaning of the law. So if you wanted to go about it differently, then fair enough. But, that's it. Yeah. And we'll pursue things as we do. Well, I got to actually start working on a response in my case in the Western District. One of our defense, one of the defendants has filed for a motion for summary judgment. So I need to start working on that. Plus, I need to talk to my client. She'll pick up the phone. Oh, they're going to give a verdict on P. Diddy on the sentence? Okay, I'm in for that. We'll stay and watch for that. You're waiting? Okay, well, we'll call you back after P. Diddy. Yeah. Apparently he's crying. Nice. We get a nice little view we'll get a nice little view outside the courthouse since we can't watch it one inside the courthouse. Well, let's see what's going on here. Can rent increase be retaliation? If it were excessive, sure. Yeah, if it were beyond what they normally do, yeah, could be in principle. So if they jack the rent like incredibly up, yeah, that'd be a retaliation too. You think he's going to get time? Someone think that chat thinks he's going to get time served. Let's see if we can find out what's going on. Yeah, I think that there's going to be some prison time here. Yeah, I think the judge is kind of pissed. We'll see. Who's live tweeting this? Someone's got to be live tweeting this.
Gotta give up.
They maxed out the emotional card? I bet they did. Apparently, they played a video right now in court. All right, NBC News, live updating. Okay, as of 5 minutes ago, defense was explaining Combs' speaking engagement. 10 minutes, 16 minutes ago, my client is not a pimp. His attorney saying the government equates Sean Combs with a pimp. I want to be clear, Mr. Combs is not a pimp. I don't know, man. I don't know. A pimp is in the business of subjugating women, therefore he should not be considered a pimp. A Miami pastor asked the judge to free Sean Combs from jail, saying no amount of time spent behind bars will change his condition. He went on to say, quote, as Michael Jordan said, these sneakers are just sneakers, but when Sean does things, he turns them into opportunities. Sean needs an opportunity. I'm asking you to give him to us, and we won't let you down. Uh-huh. Apparently, there was some bullshit video played in court. Let's watch the bullshit video for a while. This will be good.
When my baby cries. We gotta give her a bottle then.
Know that you mean something to people. Know that you mean something to people. Like you live somewhere in people's heart.
My nose fell off. No, then my lip fell off. Thank you. You wear it?
It's got copyrighted music in it. I'll chance it. Apparently, they played it in court. I'm considering this fair use. If this is evidence they played in court, I'm considering this fair use. Come on.
You inspire, you energize, and you've left that for the rest of the existence of this planet, man.
They probably will copyright strike me. I'll be like, bullshit.
One thing about great producers is they make you want to do better and be better about what you do. And he made me feel like I could do anything and go anywhere.
I guess hypothetically we could strip out all the music, although it's probably too late for that at this point. But we could actually strip out the music. Okay, hold on. We can do this. We can do this. This will take a second, but we can do it. You can do it after? Yeah. Let's see. Someone's got to be doing live tweeting on this. New York Post, what you got? They only got 60 minutes ago. That's no good. Music was lame. Inner City Press? Yeah, that's usually a good call. All right. Yep. Okay. How do I strip out audio from a mixed feed? Magic. All right, here's some tweets. Let me see what I can do in terms of like, hold on. All right. Okay, cool. Let's see. Now I need to do this. You're in my car. I am safest of all. Lock all my doors. I went to the gym 23 times last month, by the way. The month before I only went 22 times, so I actually went one more time last month, even though one, I was sick for a week, and two, there was one less day in the month. So I did pretty well for myself. 23 out of 30 is not bad, man. I'm respecting myself. You went 0 times? You guys saw my 701-pound leg press that I've uploaded? That was pretty cool. 6 plates plus like 15 pounds on each side. A 6 plate plus 30 pounds. That's nice. That's 12 plates total, right? So 12 plates plus 60 pounds plus the sled itself. 701 pounds. Nice. My legs have got some strength in them at least. I thought maybe it might help with the haters. Maybe the haters would hate on me less if I posted some of my workout results. Although there's still some haters. One was, you know, not happy that I did a Smith machine deadlift that day. I alternate, by the way. I alternate, you know, between Smith and regular. And they were unhappy I did a Smith machine. One person was unhappy that my squats weren't deep enough. It's always a critic, man. That reminds me, by the way, I still need to take my testosterone today. I still haven't done that today. Now would be a good time to do that. Let's inject together. Let's get that injection life going on.
You've given to the world. I don't think you know.
All right. Let's see if this works any better. All right, hold on. All right. This is kind of jank. If I do this, will it work? I bet it will. It'll look like shit because I'm making what's 240. I'm making a really small 240 like much bigger. So the video quality will be kind of shit, but it'll work. All right. All right, let's give this video that apparently Sean Combs submitted to court another shot. This time, maybe without the video. Let's see how this works, or without the music. Let's see if this works any better. All right, hold on.
Hey, man.
When my baby cry.
You gotta give her a bottle then.
Know that you mean something to people. Know that you mean something to people. Like you live somewhere in people's heart.
My nose fell off.
No, it's here.
My lip fell off.
Thank you. You wear it?
You inspire, you energize, and you've left that for the rest of the existence of this planet, man.
Uh-huh. Nice.
One thing about great producers is they make you want to do better and be better about what you do. And he made me feel like I could do anything and go anywhere.
From New York. I love New York. I love the city of New York. I love the children of New York. I wanted to do something good. I wanted to get my generation in the hip-hop community behind us. They come through in a big way. And we wanted to raise some money for the children of New York City for health and education. We have a huge education crisis. And, you know, this is just a start. It's something we're going to be committed to. I'm going to be committed to for a lifetime. And it's no better way than taking it to the streets. It's a beautiful city running all around. The city's going to be painful. It's going to be rough. But, you know, if we get through it, then it'll show kids and everybody else that, you know, finish what you start and you can do anything you put your mind to. Any of y'all go to public school? Okay, y'all running to raise money for your schools. So y'all get more books and computers and stuff like that. I just feel like it's important that us, you know, young adults of power, that we look out for y'all. And we utilize our power to make sure y'all all right in the future. Put everything you can into your work, you know. Don't think the cool thing is not to do your work. Don't think the cool thing is to hang on the corner with your friends and to talk about stuff that ain't gonna protect your future.
What did you learn about him as a man who was taking up a new sport?
Well, you know, I was actually very impressed. You know, a lot of people think it's just a celebrity stunt, that he isn't serious about his running. He is as serious about his running, has been the last 9 weeks as a lot of these guys in the lead pack. I mean, he's really devoted and dedicated himself to running. You know, he's had some knee problems, and
He's a really good and really dedicated runner. Therefore, something you shouldn't send him to prison for the pimp parties and stuff. Okay. All right.
And a lot of people don't think he's going to finish. He is going to finish, even if he has to do it on one leg, because he's raised a lot of money for kids' charities, and he's not going to let all those people down.
Let's go. We're going straight to the top, baby. Let's go is a constant reminder. Let's go. Boom. Live in the present. Sometimes, you know, you daydreaming. Sometimes, you know, Uncle Diddy got to hit you with let's go. Clap it up on the sideline. Get our energy right. Come on. To make sure that you pursuing your dream, that you staying focused. Let's go. Let's keep going forward. Let's go means let's be positive. Let's take it up another notch. Let's go spend time with our kids. Let's go. Let's give thanks to God. Let's go. You know, let's turn it up. Let's get in the vocal booth. Let's stop procrastinating. Let's go. You know, let's understand what it's going to take to achieve that dream. So instead of talking about the guns or the violence, I was always talking about a better life. Places we didn't go before. Things we never wore. Cars we never drove. Houses we never lived in. I think I brought an aspiration to hip-hop. Tried to take it out of just being street. Our whole stuff was a fantasy and a dream that I always felt would come true. I started out just like you guys. I come from New York. I grew up in Harlem. I used to have to wear a uniform every day. Had to get up early in the morning, had to travel to go to school. I worked hard, just like you guys are working. This country and this world we live in may have plans for y'all. I didn't listen to that, and I don't want y'all to listen to it either. Y'all are great. Y'all are kings. Y'all are queens. Y'all are leaders. I just got so excited.
All right, so apparently his lawyers, as of 5 and 2 minutes ago, respectively, said the following in court. I'm asking you to release him today. He's been punished publicly. Everyone knows the twists and turns in this case. This is also a form of general deterrence. The publicity he's got, Ms. Ventura's lawsuit, it destroyed his business. We're proposing mental health treatment, a domestic violence program. Sometimes group programs are the best. October is Domestic Violence Awareness Month. I'm not asking for a light sentence. I'm asking for mental health, the root problem. Lol. Pressing back to this self-serving bullshit video that apparently was played in open court by the defense team. Apparently they thought this was a good idea. Okay, let's watch some more of this bullshit. It goes on for another 7 minutes or so.
Because this is truly a dream come true for me. And I'm happy to say this is our 3rd school we have opened. It's official. When we come together as the people, nothing can stop. But what I want to do with my freedom is, make sure that I can make change.
And I found out that Mr. Sean Diddy Combs posted me on Instagram. We met Sean Diddy Combs for the first time, and Sean gave Trey a $25,000 grant, which allowed us to open a physical store.
Revolt as...
They're using an appearance by someone on Shark Tank to say what a great guy he is. That's fun. I like that. That's good. All right.
One of the only Black-owned networks. We have to own something. We have to have something that's ours. We have to have something that we can control our narrative, and we could speak about things that are important to us, and we could have a platform and a foundation to be free. But I want to get advice from y'all. I want to not just have a one-way conversation.
We need a platform where they can put artists that are different, really different, that wouldn't get a shot on other stations.
Working for Revolt TV and working for Diddy was absolutely life-changing. It was the best job I've ever had. I learned excellence through him.
I don't see enough of things truly changing. And I don't understand how we are the richest, most powerful country in the world, and it seems like we can't solve the problems within our own community. African American communities are last. And the only people that are going to change that is us. So we have to stand strong together, and we have to get to that change.
You will change the world.
I've been through hell.
Yeah.
But I'm gonna make it.
You're going to make it. That's right. And I got something for you. Remember I told you I had a present for you?
Yeah. I ain't that pretty.
This is a heart, because you're my heart.
Oh.
All right?
Okay.
You my heart.
Okay.
May God bless you and keep you happy and keep you thinking positive. Everything's not going to be perfect at this time in life. And you good. You're a good person that understands reality. So we're gonna accentuate the positives in life. Cause you're doing great, girl. You're doing great.
God knows.
You know what I'm saying? You're doing great. I want you to be happy about your life. You're doing great. We got a lot of living to do now. Don't have me come behind you. I'll take you everywhere. You be going everywhere.
You hang out together.
Okay,
You were a little boy, Jeannie, Ned.
Okay.
Yeah, you just keep hanging in there.
Thank you very much. I'm telling you right now, you did a great job.
Thank you.
I'm wrapping my head around and meeting you, and I'm telling you, you did a great job at the same time.
I'm
So pleasure to meet you.
I'd rather at the end of the day be the one standing there with you was the best person. You made us feel the best as a person.
What? That seems a little rich. I was the best person? I don't know, man. I don't know. All right.
How old are you? How old are you? 2. You got a 2. That's 2.
My name is Pookie the Bird. Pookie.
Happy birthday. Wash your hands, because we're going to be shucking it up. Open your mouth. Yeah! Hallelujah, hallelujah, hallelujah. Thank you, God. Today, God is the greatest. He blessed me.
Is this video supposed to have the effect of pissing me off? Because it kind of is having the effect of pissing me off.
My girlfriend Kim in the world with 2 beautiful baby girls. She asleep?
We have breaking news to tell you about now. Model and actress Kim Porter, who shares 3 children with Sean Diddy Combs, has been found dead.
She just loved me unconditionally, you know? She just loved me just for me. It's like the closest you could be like with a person.
I get to thinking about her, and I go to crying about her.
Today, now I'm a full-time dad, and I'm gonna be there for you through everything, all of y'all.
Every Sunday, I gotta slow everything down and do the family ritual, get the family together, make sure the girls watching church.
There is a definition of grace that is more.
Pops, I love you. Thank you for loving us. Thank you for loving me. Thank you for inspiring.
I've looked up to you and admired you outside of you just being my father, just you being just a great human being, a kind human being.
I love how you inspire me to keep going, to never stop following my dreams, to always believe in myself.
See your foot, put in that middle part.
Yeah, I did.
I wanted to tell you how much I love you, how much I care for you. Thank you for being so supportive of me and my siblings' dreams, for always encouraging us to go for whatever we want. We love you. We can't wait to make more memories with you. And Brian, thank you for everything you do for us. Yeah, and let you know that you're loved more than you think.
If I had to pick which trophy I want the best person trophy. But I know in order for me to get into heaven, I'm not going to get in there, well, come on in heaven, you had 20 hit records. That don't mean nothing, and that's what this world is for. They're going to say, oh, come on in heaven, you was a nice person.
I love you.
I love you so much.
I love you so much.
I love you so much.
Hi, Daddy.
Well, that was it in all of its glory. I'm not sure what we learned from that, but okay. Okay, so they're on break now for 8 minutes, and then Sean Combs is going to give remarks for a couple minutes, and then the judge is going to impose sentence. So we're going to camp out here, I guess, for another, and also it depends how long the judge takes in actually giving sentence. So we might be here for another 20 minutes or something. Maybe 25, depending. It's only like one charge though, so it really shouldn't be that long. And hopefully the judge will save us a lot of time and just like not say a lot of verbiage. I think as a judge, I would be disinclined to like do anything other than just pass the sentence, like literally. Just be like, I'm just going to give you the number. I don't need to say anything at that point. I don't need to add words of condemnation. It doesn't matter anyway. And everything that needs to be said has been said by that point. There's no reason for me to say anything else. Just let the sentence speak for itself. Just yeah, if I become a judge, I think I'm just going to be like, just to the point, man. Just give you the answer. No waiting, no delay. Just give you the number. Also, less to appeal on, right? Because like I just give you the number. And if I need to say anything for the record, like because there's statutory factors to apply or anything, I'll just say it in writing. So if I need to like explicitly, find things or something because of the statutory factors or whatever, I'll just put it in the sentencing memorandum. Yep, that's what I understand. Yep. So so they come back at 4, which is in 6 minutes. Diddy has 5 minutes to say something, and then like the judge speaks for however long they want to speak, I guess. What'd you miss? Just seeing how things pan out for Mr. Puffy, Mr. P Daddy Puffy, P Diddler. Also, it also depends if the judge wants to take a break before imposing sentence. If the judge needs to think about things, right? So if the judge needs to like, okay, we're on break for a half hour as I ponder the mysteries, that could be a thing too. Let's see what's on lifting for today. What theoretically am I supposed to do in terms of lifting today? Let's see. What's on the agenda for today? Back, triceps, biceps, and abs. Okay. It wants me to do some cable row. I'll do that. Reverse grip pull down. I can do that. Cable shrug. Doesn't feel like that useful of an exercise. Let's see if there's something else that would be better. Cable upright row is good. Or dumbbell upright row. Let's do dumbbell upright row. That's good. Okay, dumbbell bicep curl. Yeah, I'm in for that. Preacher curl. Maybe. Mountain climbers? No, that's okay. We'll do cable crunches instead. And side plank, if we have the energy for it, we'll do wood chopper. All right. The preacher curl might be a little bit much on top of everything else, so I might save that for last. Could be a good workout. We'll see how it goes. You guys don't want to talk about workout? Thank you. I could do T-bar row instead of cable row, which is tempting. Or I could do like dumbbell row. That's also tempting. Cable row isn't bad. I'm getting pretty close to maxing out the stack though. So that's funny. I'm maxing out the stack on some of my exercises at this point, which is pretty funny. I wonder if they'll have posted the workout results for September yet. They didn't yesterday. So I can see what my standings were for last month. See if I improved at all or went down. I'm just impressed I managed to go to the gym 23 times, being sick for a week. I'm surprisingly impressed. All right, it's 4 p.m. All right, so apparently prosecutors are actually asking for 135 months, 11.25 years. That's aggressive. Defense is seeking 14 months, time served, and probation recommends 5 to 7 years. Yeah, that sounds more plausible. 5 to 7 years, that sounds more plausible. Prosecutors are being aggressive at 11 years. Yeah, 5 to 7 years seems like sounds like a very reasonable prediction. I still need to do like lower back exercises. You know what I should do? Instead of doing instead of doing preacher curl, I'm gonna not do that. But what I will do instead is I'm gonna do some hyper extensions to work on my lower back, because my lower back is by far and away the weakest point of my body. Yeah, I'll do some back extensions. It's going to kill my body. It's going to kill my back, but that's kind of the point, to get some strength there. So I'll do that instead of preacher curls. That'll be a good workout. Work on my lower back a little today. Yeah, that makes sense. Or I could do cable pull-throughs, which would be a little bit less brutal. Let's ask ChatGPT what it thinks. I can't do a sit-up to save my life, man. I got a big-ass stomach in the way. Hamas accepted Trump's peace deal. All right. Back extensions it is. I'm going to die, but I'll do back extensions. Probably just like use a 5-pound weight or something like really stupidly low for back extension because it's hard enough as it is. Excuse me. Now would be a good time to take my testosterone injection before I forget again. So let me do that real fast. I'll be right back. Okay. Let's see. No updates from Air City Press yet. I mean, develop a soundtrack wouldn't be the worst idea. Maybe we can get P. Diddy to do some soundtrack for us. My name is Hove. I don't know, whatever. That's Jay-Z, though, but not Puff Daddy, so I don't know. Yeah. right. That's all taken care of. Excellent. How much does Comet's plan mitigating? As much as the judge wants them to make. That's why it's up to the judge to decide how much it matters, or it doesn't matter. So, how much does it matter? You have to talk to the judge. Tell it to the judge, baby. All right. He's blaming drugs? Of course he is. He blame anything except himself. It's the drugs. It was my fame. It was, whatever.
Welcome back to the AP News live stream of the Sean Diddy
All right,
sentencing. He's in this federal courthouse behind me, and he's speaking now to the judge.
Apparently he is making statements. Let's see if I can find exactly what our genius friend is saying here. All right, let's see. Okay, no, still no. Still no. Still no. Okay. Sean Combs says the following. One of the hardest things I've had to handle has been having to be quiet and not express how sorry I am for my actions. I don't take that lightly. I'd like to apologize to Cassie Ventura and her family. I apologize to Jane for bringing you into my mess. I'd like to apologize to all the victims of domestic violence. I know the disgusting video triggered people. I was sick from the drugs. I needed help, but I didn't get help. I knew better. My faith taught me better. I'm not this large-in-life person. I'm just a human being. I'm trying my best. I lost my freedom and the opportunity to raise my children and be there for my mother. I lost all my business. I hate myself right now. I've been stripped down to nothing. I want to apologize to my 7 children. I'm so sorry. You deserve better. To your mother, I feel you taught me better. Exciting. I let down my community. I wanted to show we could take care of our own problems. I got lost. I'm not this bad person. I'm sorry to my community. I let you all down. People can change. I know I've changed.
Sick. Now, Diddy gets a chance to address the court. He gets the last word as the defendant. Remember, he was found guilty of 2 counts of the Mann Act, which was related to prostitution. He was found guilty of flying around his girlfriends and male escorts for sex. That charge carries a maximum of 10 years. Now,
Sometimes you have to go through life experiences. These are not excuses. I can't change the past, but I can change the future. I beg your honor for mercy. To be a father again, to be a son again, a leader in my community again, to get the help I need.
court, and he let out an audible sigh after apologizing to the community. This is right before the judge will decide what his sentence should be. Will he be out, or will he spend the next several years in prison? Reporting live from the federal courthouse in Lower Manhattan, I'm Julie Walker. This is the AP News live stream of the Sean Diddy Combs sentencing.
Very exciting. I don't think he's going to get time served. I don't see that happening. I could see him like getting only like a minimal sentence. I could see him like only like having to serve like, I could see him getting some like a minimal sentence if the judge wants to, but not pass. I don't think so. I don't want to let God down. I have no one to blame but myself. I know I'll never put my hands on another person again. I'm willing to comply with any conditions. Me sharing my story, it's not a scheme to get less time. This story is tragic. Tragic! Yeah, he has the judge mad. I tend to agree. I don't think he's going to get, low-end sentence. 3 to 5 years is very possible. Yeah. If he gets 3 years, if he gets 5 years, if the judge is like, no, fuck it, we're going to start stacking sentences. Yeah. 10 years, he maxes it out on both at 10 years and runs it concurrent. That might happen. It's like 10 years for each charge, run it concurrent. I can see that happening. You booked a speaker interview for Monday and it pissed the judge off? I bet it did. Yeah. If Your Honor gives me a chance to share my story, this has a positive impact. Thank you for the jury. Your Honor gave me the confidence in the jury to believe that I didn't have to testify. They sacrificed 8 weeks. I thank them for not guilty. Rule one of litigation, don't piss off the judge, right? I tell you guys, man. It's a critical rule. People seem to forget it for some reason. I don't know why. It seems pretty obvious, but I take full responsibility for my Mann Act convictions. They want you to make an example of me. I want you to think about making an example of what a person can do if they get another chance. Consider the beautiful children who spoke for me? Really? No matter what anyone says, I know I am truly sorry. Thank you, Your Honor. Excellent. Does he actually have gigs scheduled? Does he have like singing gigs actually scheduled? Does he actually have singing gigs already on the books for the future? As a judge, that would piss me off so much, man. The hubris. You can't. Interviews. The hubris. And the judge says, let's take 5 minutes. Okay. So the judge apparently is going to go away and ponder for 5 minutes and return with the page he already had written up. All the judge has to do is fill in the last numbers. right? He has everything written up, and all he has to do is fill in the blank. So we're on a 5-minute break, and then we find out what's going on. Exciting. Sounds like he didn't move the judge very much. The judge is like, I just need enough time to fill in the blanks. Yeah. He has several speaking gigs. How much jail credit is he getting? Oh, I think it's like a year and a half or something. They've already got the microphone set up outside. Do you think they have recording studios in federal prison? Maybe we can just get him laying down some beats on some tracks or something during his phone calls or something and do it that way. I don't know. What will it be? Will it be the 3 to 5 the probation recommends? That's likely. Will the judge go with the prosecutor's recommendation? I kind of secretly hope. That'd be good. Yeah, I think I had said like 5 years was basically what I was predicting from like way back when he was like found convicted. I think 5 years is what I said, if memory serves correctly. So it's been a while though. Thank you, Paul, for the $2. Really do appreciate that. Do appreciate everyone who helps to support the channel. Well, we should be getting an answer pretty soon, guys. Any moment now. Is this a record for a sentencing hearing? Not really, but it is longer than a lot of them. But yeah, sentencing hearings, they've been known to go on for a couple days sometimes, but although that's usually death penalty cases, but it's not like an absurdly long time, although it is a lot for this particular case, but it is what it is. Just Rhonda, appreciate, thank you very much. Give memberships. Come on. What's it gonna be?
Time to turn on the wireless. Yes. Good idea. It's about to start. How lazy is this? Is this too lazy? Just letting it right here? No, you good. Yeah, we'll pick. 1001, 1002, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Diddy did it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Diddy
Nice.
did it. Check 1, 2. You good, Vic? Everybody good? You need any more? One, two, and two.
They probably have their notice of appeal ready to go, ready to file. They just have to fill in the like blanks, right? Like, how fast can we file this appeal before the day's out? Probably. Well, come on, Judge. Give us the answer. We're all dying. All right, they're back. The judge said, at the outset, I want you to understand, Mr. Combs, you're not being sentenced for acquitted conduct. This is something they changed in the federal rules a couple years back. So it's constitutional, but they changed in the federal rules a couple years ago. Under 3553, I must consider many things. Mr. Combs, you're a self-made artist who's inspired community of color. Exciting. We saw the video. The free game course in the MDC. The court hopes you continue to expand it. You're devoted to your family. The court, of course, considers the collateral consequences. The court has to consider all your history here. Yeah, he's saying things. He's going to give a little speech now.
Welcome back to AP News live stream of the Sean Diddy Combs sentencing.
A history of good work can't wash away the record in this case.
Right here.
You abuse
And
these
he
women.
already got to
You use that
address
abuse
the
to get your
judge,
way.
saying
Freak
that
offs
he
and
believes
hotel
he's a
nights.
changed
The evidence of
man and
abuse
that
is massive.
he deserves
I
to
was
be
sitting right
out of
here
jail
during
with
testimony.
time served. Prosecutors want him behind bars for 11 years. Now, the judge had said to him, Mr. Combs, you're being sentenced for the offenses.
Yep. History of abuse is massive. That was subjugation. That's the reality of what happened. These offenses irreparably harmed two women. You plied them with drugs. Why did it happen so long? You had the power and resources to keep it going. You were more than a John. Nice. Because that was something the defense was trying to say. Oh, all I was a John. That's one of the things the defense was trying to say. Like, no, not so much. A significant sentence is required to deter. You say you're sorry and you won't do it again. After Miss Ventura's civil lawsuit was filed, after the video was public and the investigation started, you had a brutal hotel night with Jane, punched her in the head. Yikes. That doesn't sound good. Jane says he told her, take this pill, do out there, and suck his dick, fuck him, I don't care. The court is not convinced this would not happen again. The court has considered the programs. They are outweighed by the trial record in this case. Yeah. Yeah, trial court in the federal system is never televised. Sometimes the Court of Appeals is, but yeah, trial court is never. Yeah, just the way it is. Exploitation of violence against women must be met with real accountability to promote respect to law. The court reaches a few conclusions. 135 months would be more than necessary. A sentence over 11 years is not reasonable. Even probation department recommends a sentence less than half of that. But 14 months, time served, would not be sufficient. There's no audio feed because she's just saying the same thing I am. She's just reading tweets and stalling for time, same as me. So there's nothing really to watch or listen to. She has no knowledge that I don't have, I assure you. She just has a fancier camera. That's it. And if I do say so myself, I don't think she's even more entertaining than me. But yeah. So is the probation number the right number? Is he going to give him the probation time? I could see that happening for sure. All right, here we go. Let's see. Here, the data shows a wide variety of sentences. Weighing all relevant factors, the court determines that a sentence is 50 months of incarceration, 50. So that's 10 less than 60, which is 5 years. So that's 5 years and 2 months. Wait, 4 years and 2 months? Yeah, I think. Yeah, because four times 12 is 48 plus 2. Yes. 4 years and 2 months. And then you get time served, which is what, 18 months? Oh no, it was 14. Okay, so that leaves 36, which is 3 years exactly. And then you get to what is it, 85% time with good behavior. So, hold on. Let's see. 36 times 0.85 is 30. So that's 2 years and 6 months and a half. So 2.5 years. Yeah, 2 years, 6 months, and 15 days. Yeah. Okay. That's what we came up with. Okay. Yeah. So that's the number. Neat. That's a pretty serious sentence. Maybe not as much as I dreamed, but not unreasonable. No, that's total time. Well, 2.5 years would be in addition to what he served. So 2.5 years more. Yeah. I did all the math. The judge. Any recommendation where to serve the sentence? The defense lawyer. Can we get back to you now that we know the sentence? Yes. Can we get back to you on Monday? Okay. So okay. They don't have probation. They have early time. It's not the same thing. Yeah, federal does not have probation or parole, but they do have good behavior time. So times 0.85 for good behavior, because I assume that he's going to have good behavior. So that's where I got it from. So 2 years, 6 months, and 15 days. Probably served it like a minimum security facility. You know, because they're not violent crimes inherently, and it's a light sentence. So probably some nice tennis club fed, probably club fed for 2.5 years. So could be worse. Could be worse. He can work on his tennis game or golf game or something. Well, guys, I guess that's pretty much the end of that. So yeah, 2.5 years in club fed. That's basically what's going to happen. I'm pretty confident. Or other minimal facility. Yeah. So and he'll work on his tennis game or golf game and maybe pump some iron, and it won't be so bad. Could be worse. So yeah. Fines and costs. Yeah, for whatever value it has. I mean, the fines and the costs are nothing. The costs are really nothing, even to a poor person. To be honest, the costs are so pitifully low. Fines. Is there any court order restitution? Not that I saw. Not so far, at least. So, oh, here we go. The court imposes a fine of $500,000. Ooh, will you take the change I found in my couch cushions? The court imposes a fine of $500,000 to including defraying the cost of imprisonment. There's no restitution, but there is forfeiture, as reflected in the order. There's a $5,000 fine under statute and a special assessment of $200 because it's always the special assessment. So yeah, we'll hunt in the couch cushions for the $505,200. Yeah, do you accept Amex? Yeah, so exciting. Yeah, Lord. Victim got $30. There you go, man. You get it where you can, baby. No, you can't claim fines deductible from your taxes. No, that is not an expense you can deduct from your taxes. No, absolutely not. Yeah, that's funny though. PayPal? I don't know if the court takes PayPal, but yeah, we'll give you a cashier's check. I mean, it's fine. Well, the fines are part of a business model? No. No. He's worth $1 billion. Yeah, $500,000 to him is what? The equivalent of, well, let's see, it's half of $1 million, which is 1/2000th of $1 billion. So let's see, for you and me, let's say that you make $100,000 a year. So that would be the equivalent of, hold on, I can do the math. $500? Yeah. If you make $100,000 a year, that's the equivalent of $500. You'll be fine. Yeah. Well, guys, I guess I'm going to go ahead and sign off and try to make it to the gym after I call my client. So I'm going to hang up here or stop streaming. I'm going to have a little bit more lunch. I'm going to call my client and then I'm going to go to the gym in that order. That's how I'm going to be productive today. And I'll send you the results of the leaderboard from the gym, I guess. Let you know how I'm doing. So, yeah. All right. I'm going to go ahead and sign off for now. This has been fun. We will be back soon enough. I've been Uncivil Law. Do I want to go dancing tonight? I'm kind of still a little under the weather. Maybe I'll give it another week. I want to take up dancing. There's a good dancing thing on Friday nights, but I'm still not 100%, so maybe I'll give it another week. All right. I've been Uncivil Law. Till later, my friends. I hope all's well. Cheers for now, my friends, and goodbye.